unmute yourself.
With the TV on, we keep the CPU up, but that is not that.
Okay, I just muted it. So today is July 27, 2022. It's 8:30 in the morning. Preliminary hearing calendar. My name is Brad Gardner. I am presiding over the case of State of Georgia versus Kiana, Qiana Williams. Ms. Williams is charged in warrant number 2022 WA 10074 with committing the offense of criminal damage to the property in second degree. Ms. Williams is present. She's represented by attorney Rhonda Hill. The state is represented by attorney Cheryl Freeman. Ms. Freeman, would you please swear in your witness and present your case?
Thank you, Your Honor. Officer Mays, would you raise your right hand, please? Do you swear and affirm that the testimony about to provide in the matter of State of Georgia versus Kiana Williams will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Please tell us your name and how you're employed.
My name is Benjamin Mays III, badge number 29948. Work for Clayton County Police Department.
How long have you worked with the Clayton County Police Department?
For a year and 8 months.
And sir, were you working with the Clayton County Police Department on June 23rd of 2022?
That's affirmative.
On that particular day, were you dispatched to 9155 Welch Court in Jonesboro, Georgia?
Yes, ma'am.
Is that in Clayton County?
Yes, ma'am.
Why were you dispatched to that address?
Dispatched in relation to a disturbance between a Miss Morgan, Danielle, and a Miss Williams. Apparently, it was reported that she was acting irate, that she pushed her way into a bedroom, destroyed a outside wood railing, threw some clothes out in the street, threw a garbage can. Also did some damage to some ceramic trinkets inside of the home, as well as a guitar and some other miscellaneous damage.
And also, Mays, just going back when you said it was reported that she did this damage. Who is the she you were referring to?
She I'm referring to as a Miss Kiana Williams.
And who was the person who reported this?
Her roommate at the time is Danielle Morgan.
Was this address a home, or I'm sorry, a house or apartment?
Yes. No, it was a house.
You stated that Miss Kiana Williams was the roommate to Miss Morgan?
Yes.
Did Miss Morgan own the house?
I'm not sure.
The items that you indicated that were damaged, did those items, I guess, belong to Miss Morgan?
Yes, most of them did. I'm not sure if all of them did, but there was clothing, and again, it was damage to the home itself. The guitars was hers, and a few other items.
Okay. Were you able to get an estimate for the damage from Miss Morgan?
Yes, ma'am.
And what was that amount?
Amount was about $1,900.
Did Ms. Morgan indicate how long Ms. Williams had been residing there?
Yes, ma'am. She stated that she was out there for about 6 months.
When you arrived there, Officer Mays, was Ms. Williams still there?
No, ma'am, she wasn't.
Did Ms. Morgan have any idea where Ms. Williams had gone?
No, ma'am. Miss Daniel, actually, I did. Apparently, she had gone to another friend's house, and then left that location.
While you were still at this residence, Did you receive any other information regarding Ms. Williams from another unit?
Yes, ma'am. Received some information that she had gone to another location and went into someone else's house. There should be a supplemental report. I'm not sure that should be with the other unit involved, but she had gone to another location and entered someone else's home.
Did that other unit, did they arrest her?
Yes, ma'am. Apparently they detained her at the time.
And from your investigation, did you learn as to whether or not Ms. Williams made any statements regarding what happened at Ms. Morgan's house?
Ma'am, what she was saying was a bit incoherent, and it's in my report. She said something about she had to get, again, this is in the report, that she had to get them babies. She was clearly a bit incoherent and rambling, to say the least. And again, I'm no doctor. I can't diagnose anybody, but she didn't seem coherent.
Did she make any admissions regarding what happened at Ms. Morgan's house?
Again, during her rambling, she said she had to quote, get those babies. When I did ask her if she had done it, what she had done, she was giving answers that led to the affirmative, but again, it was a bit incoherent. And a lot of the questions I was asking were answered with unrelated answers and unrelated questions to as responses.
When you were interviewing Ms. Morgan, did she give any indication regarding any, mental concerns that she may have had for Ms. Williams?
When I was interviewing Ms. Morgan,
yes,
she did. She alluded to some sort of possible PTSD, and again, this is only coming from Ms. Morgan. Again, I'm no doctor or anything like that, but she did state that she could possibly have some sort of PTSD from military action or something like that.
Did this happen in Clayton County?
Yes, ma'am.
Thank you. No further questions.
Ms. Hill?
Thank you. Officer Mays, let's start with the testimony of Ms. Morgan. Did she say she actually saw Ms. Williams destroy these items?
No, ma'am.
Okay. So what led you to take out the warrant?
Well, she did say that she came at the door. So she did say she was trying to push in the door, and then while Ms. Morgan was upstairs, she didn't see her do the stuff outside. But she did, I guess, witness her leave the property. Also, there was a case earlier in the day.
Okay, that you answered the question, Officer Baker. Let me ask.
I want to ask that the officer be allowed to finish his answer.
Finish your answer, Officer Mays.
Yes, Your Honor. There was a case earlier in the day where Ms. Morgan reported that Ms. Williams was wielding a machete, and I have the case number again. It's referenced in my report, wielding a machete earlier in the day. So that's your question was why I felt the need to get the warrant. So that was a part of the reason of getting that warrant, because of the alleged earlier incident.
Okay, Officer Mays, let me also ask you, you said that You created this police report, right? You drafted the police report?
Excuse me?
Did you draft the police report regarding this incident?
I did write a report about this.
Okay. Is the police report, does it accurately reflect the amount of damages that you say Ms. Williams caused?
As reported to me by Ms. Morgan, this is an approximation of the damages to the property that's listed in the report.
Could you recall the amounts for the court?
She has here a ceramic pig head from Mexico. She counted the value at $250. She has an air fryer, counted at or valued at $150. Then she has a wooden front porch railing that she estimated at $1,500.
Okay. And let's see, Officer Mays, how were you able to determine whose property was what? You said that they were roommates, correct?
Yes.
So did Miss Morgan state that all of those items belong to her?
That's what she stated to me.
But you were not able to determine who owned the house, is that correct?
No, ma'am.
Okay. Let's see. All right, so let's get to this alleged confession. So you said that you asked her whether or not she damaged the property, and well, you asked Miss Williams whether or not she damaged the property, and her response was she had to get those babies.
Ma'am, that was one of her responses. Again, she was rambling.
Right, and you took that to mean that affirmatively that she did?
No, ma'am.
Okay. So in that case, then she did not admit to damaging any property then? Okay.
No, ma'am.
All right. At what point did you read her Miranda rights?
I'm not sure she was Mirandized. I don't think I Mirandized her, but I'm not sure the other officer Mirandized her while on scene earlier.
Okay. Let's see. Was there any video of the alleged incident?
Video of, say again?
The alleged incident.
No, ma'am, none was provided.
Okay. All right. No further questions, Your Honor.
Any redirect?
Yes, Judge, just because I wasn't clear on Officer Mays' response when Attorney Hill asked you whether or not the defendant admitted to destroying the residence. I wasn't sure what your response was because I know when I asked you the question on direct, you indicated that that she was incoherent, but her responses led you in the affirmative. And so I'm just trying to get some clarity. Did you indicate in your report whether or not Ms. Williams made an admission to destroying the property?
I did in the report.
Okay.
So, Officer Mays, so that you know, I don't have your report before me. So when you respond that I did in the report, can you just clarify that? Or expound on it, I'll say that.
Okay. Again, the responses I received from her as she was giving me responses were a bit incoherent. They were, it was a bit of rambling. And again, she made that comment that I had to get them babies when I asked her if she had done what if she had committed the act. That could have been implied as an affirmative. But again, I just wanted to make sure I was clear that it was a bit incoherent and some of it was unrelated. So I took that as an admission that she caused the damage, and I put that in the report.
Okay, Mays, Officer Mays, it sounded like you kind of skipped the beat. You asked her questions and then she admitted in the affirmative. I got a small brain. Can you just break it down for me a little bit so I can understand what you're saying?
And Judge, what may help, because, and I believe Attorney Hill has the report, I have the report, I think that Officer Mays has the report. Instead of, I guess, trying to, I don't know, come up with an explanation, if you could tell us specifically what is it that you stated in your report?
Absolutely.
And then if you need to explain, you can explain.
Absolutely. Where would you like me to start?
No, we're asking the question about whether or not Ms. Williams made any admissions.
Right. Before being transported, offender Ms. Williams admitted to destroying the residence of Ms. Morgan, stating that she had to get them babies. Ms. Williams was a bit incoherent and provided answers unrelated to the questions asked. And at the conclusion of my investigation, due to prior event or prior incident earlier in the day.
No, we don't need you to read it, the other stuff. No, we were just talking about the admission. I'm sorry.
Okay.
Right, so that is the statement. So as you testify right now, today, with your recollection, is it that Ms. Williams made an admission to destroying the property, or you made the assumption that she was answering that she destroyed the property based on her statements to destroying the babies?
Right, with the comment, right. That to me was an admission of the alleged incident. Though that comment, once I asked her, hey, did you do this thing? She said she had to get them babies. That was her answer. And I took that as an admission of the incident.
Okay.
Okay, Ms. Hill, if you have any follow-up questions based upon the questions that I asked. Okay. So
Yeah, that's all I have, Judge.
Thank you. So Officer Mays, you took the statement of I had to get those babies as an admission to destroying the items.
Yes, sir.
Did you develop an opinion as to why getting the babies and destroying those items are connected?
No, sir.
Okay. All right. Thank you, Officer Mays. You can be excused, sir. You can stay on if you would like. Ms. Hill, are you going to present any evidence?
No, Your Honor. Just argument.
I'm assuming that Ms. Freeman is going to waive opening.
Yes, Your Honor.
All right, go ahead, Ms. Hill. Give me your argument.
Judge Gardner, I'm going to ask the court to dismiss the charge of second-degree criminal damage to property against Ms. Williams for several reasons. First being that the warrant was actually based on an alleged admission by Ms. Williams, but there was, it appears to be not a reasonable opinion of an admission. I had to get those babies does not seem to be in a reasonable admission of guilt that's sufficient to sustain the warrant. additionally, there seems to be a question of who owned some of this property. The police report, as Officer May stated, showed damages of about $1,900, $1,500, which were for the wooden porch railing of the house. And the house did not belong to the roommate. Let's see, it did not belong to Miss Morgan. They were both
Judge,
residents.
I'm going to object. Those are facts and evidence about the house that belonged to Miss Morgan.
I was, but he was not. Sure.
Let's stop for a second.
Thank you.
I'm going to overrule the objection. Continue your argument, Ms. Hill.
Thank you, Your Honor. There was actually no evidence that it did belong to Miss Morgan. They were both roommates there at the property. She did not see Miss Williams destroy any of those items. And as far as the rest of the property goes in the residence, Miss Morgan claimed that they were hers, but they also could have been Miss Williams, but she was not asked about the property. She didn't give any answers about what property was destroyed and what belonged to her as well. So that the property could have actually been in dispute as well. And so let's see. So the amount in question, even if, Your Honor took the two smaller items and assumed that they belonged to Miss Morgan, would not be enough to sustain the criminal damage to property in the second degree, because that was only totaled $400. So the amount in question, there's a problem with the amount in question as well as a problem with the warrant as well. And so for those reasons, we ask that you dismiss this charge.
So, Ms. Hill, based upon the testimony that I heard, it seems like your client is in a position of being charged with 1 criminal damage to property in the second degree and 2 misdemeanor criminal trespass charges based upon the other items that were alleged to be destroyed. So the can of worms that you may be opening up, you may not want to open that up.
It is, Your Honor, but I mean, the allegation have to be true that they belong to the roommate, but I mean, it's kind of a civil issue who they belong to. I mean, she said they were hers, but she also didn't see them destroyed. She didn't see Miss Williams destroy them. Miss Williams never admitted to destroying them. We are not sure what happened. So I mean, you would be inferring intent based on not knowing what happened. So no one saw what happened to the items.
So criminal damage to property and criminal trespass, ownership doesn't have to be solely by one person. It can be joint ownership. And if there's joint ownership and you destroy the property, you've destroyed the interest that the other party may have in that property, which leads to the offense. I'll hear from you, Ms. Freeman.
Thank you, Judge. And just as Your Honor stated as well, if we were to go with that argument for Attorney Hill, but at this stage, it is sufficient that Ms. Morgan indicated that the property belonged to her. The amount that she provided, certainly we meet the threshold for a felony, a criminal damage in the second degree. And so we're asking that based on what Officer Mays stated from when he spoke to Ms. Morgan, that you bind the one charge of criminal damage over to Superior Court.
Okay, I'm going to bind this case over to the Superior Court of Clayton County. I find that the evidence is sufficient at this low standard for this one charge to get bound over.
Thank you, Judge. And may Officer Mays be excused?
Yes.
Thank you, Officer Mays. And Judge, if you can give me a moment, we'll get the officer for Charles Hill to log on.
Thank you.
Okay, and we are still on YouTube and recording.
Thank you.
Good morning, Judge Gardner.
Ms. Pleasant, how are you?
I'm good, sir. How are you?
I'm doing well. I know that you were in training.
Yes.
I'm happy to have the conversation with you and Ms. Freeman. If Ms. Freeman is available now, we can go into a breakout room and have the conversation.
Thank you.